So we thought we would address all the things that have been going on, I guess, in the last couple of months. And it seems to be changing nightly, frankly. We actually did this presentation in Houston on Tuesday, and we had to change our slides yesterday to accommodate for some things that have been going on. So I can tell you that as of, 8:31, March 2nd, the presentation is correct, but, be ready for updates. So these are the things that we're planning on going over. I'm going to talk about sort of generally what's going on with the agencies, what to watch for at the Department of Labor, including the EEOC, what's going on with the NLRB, what you need to think about with respect to OSHA, and then if you're a federal contractor, the OFCCP. We'll talk a little bit about some of the proposed personnel changes. And then I want to talk a little about the nominees and what we know so far with respect to the quote-unquote bathroom rule, because that seems to be a big concern for employers. So I thought I would give you a little information about that. Paid leave is also a big topic, so wanted to give you a little bit of, I don't know if it's a reading of the tea leaves, but a little bit of information there. And then Mark is going to spend the rest of the time talking about employee benefits issues and the IRS update, which also seems to change on a daily basis for him. So just dig right in. I like this slide. It's kind of funny. The future ain't what it used to be, right? Like every day it seems to change. Employers like predictability. We knew, I guess, at this time last year, kind of what we were looking for for the rest of the year. We knew what was coming up. This year, not so much, right? We don't have much of an idea. So this is a little bit of reading of the tea leaves, but we'll kind of see what's happening. So I put up here again the agencies that you need to keep an eye out for: DOL, EEOC, NLRB, and then OSHA. All have been doing things that affect employers. So Department of Labor generally has been extremely aggressive the last several years. We had a Secretary of Labor, Tom Perez, who was very pro-worker, and you may have seen that this weekend he was elected to head the Democratic National Committee. So keep an eye on him and his new job and what he's up to. He's been highly critical of the new regime in town, and he has been highly critical of what he sees as the future of the Department of Labor. Everyone seems to believe that it will be a much less aggressive department under President Trump. When we had Andrew Puzder as the nominee, it was a billionaire who was going to be nominated, very pro-business Secretary of Labor. I'll talk a little bit about our nominee, Mr. Acosta. He does not seem to be, first of all, he's not a billionaire, but second of all, he doesn't seem to be quite as pro-business, but we'll see what happens. With the FLSA, as you know, probably the white-collar regulations that we all thought were going into effect December 1st, those were stopped with an injunction from Judge Mazant, who is a judge up in Sherman, this right before Thanksgiving. And what happened was he said, I don't think that the rule was properly made by the Department of Labor. The way that the authority was, it was not proper. And so I think that the states and the chambers of commerce were fine to challenge it. I'm gonna stop them before they go into place so that we have time to actually look at the issue. And the Department of Labor appealed it, and they asked for expedited consideration from the Fifth Circuit, and the Fifth Circuit said yes. But I'll tell you that as of February 22nd, the Department of Justice requested an extension of the briefing schedule because they said they wanted to allow the incoming leadership to consider the issues. And so now the Department of Labor's briefing is not due until May 1st. So, we certainly have quite a while before you're going to have to worry about whether those regulations are going to go into effect. But I will also tell you that at the same time, Judge Mazant has not done anything to stay his case, and he said that, you know, there's been a motion for summary judgment by the states and also by the Chamber of Commerce to say that the rules were not properly put in place, and the briefing on that is complete. And so he has refused to stay that case, and so it very well may be that he has a ruling before the Fifth Circuit considers whether the temporary stop of the rules was right or not. So it's a big mess with this rule, and we'll just see what happens. So things are slowed down. We don't know what's going to happen. Lots of uncertainty, but that's sure to be in the news once things are decided. For federal contractors, the OFCCP has been extremely active. They've been acting with a mandate from President Obama. He signed lots of executive orders that affected federal contractors that put in place things like pay transparency regulations, things like you've got to pay $10 minimum wage to federal contractor and subcontractor employees. There's something called the blacklisting rule, which means you have to self-report if you've been acting with, you know, quote-unquote integrity. You have satisfactory records of integrity and business ethics. If your contracts are $1 million or more, you can't have mandatory arbitration of sexual harassment disputes. And so all of those things have been percolating around. And as you know, President Trump has got this, he's no stranger to executive orders himself. And so it wouldn't be surprising if he were to pull back on some of those orders, if not all, or if he stopped on, stopped enforcing some of them. So we'll see what happens there. Right now, the blacklisting rule, where you have to self-report violations of integrity, and you can't have the mandatory arbitration, has been enjoined, so that's not going on. But you are currently required as a federal contractor to give paid sick leave. You are required to pay the $10 minimum wage, and you are required to provide information about pay transparency. One thing I think people were predicting that Trump would potentially pull back on the executive order that required federal contractors and subcontractors to not discriminate based on sexual orientation or gender identity, and he made the specific decision not to do so. So that executive order is still in place for federal contractors. And, we saw a lot of litigation by the OFCCP in the latter half of 2016, and currently they are not slowing down. I've listed several of the cases out there. They sued Google for failing to submit compensation data. They sued Oracle for discrimination against women and minorities in terms of pay, and also for favoring Asians in hiring decisions. They sued JP Chase for discriminating against women in pay decisions. And then they just settled a case with LexisNexis for $1.2 million for discriminating against women in pay decisions. So you can see that pay is a really big theme going on with the government, and it's a big theme for OFCCP. So if you're a federal contractor or subcontractor, that is an issue to watch for. Okay, with the EEOC, they had adopted in October a new strategic enforcement plan, and this really gives employers a view to what they are going to really be looking for. And it's not too different from the previous enforcement plan. There was a lot of focus on, ensuring equal pay was a previous one, and preventing systemic harassment. That was from the previous plan as well. And then they're always looking at addressing emergent issues. And worker misclassification is still going to be a big theme for the EEOC. And they had also listed, as of October, LGBT discrimination. So I think one thing that we have to think about is, will this be realigned with the new administration, because the SEP, the Strategic Enforcement Plan, is not going to go away, but the priorities that are focused on are likely to be reshuffled. So, for example, with the LGBT issues, will they steer a new course? Will there be the same focus? We've already seen, and I'll talk about this a little bit later, but we've already seen the DOJ and the Department of Education have pulled back their letter recommendations with respect to, having bathrooms available to people using the bathroom that goes with the gender they identify with. So there are some questions about how that's going to work. But we believe that, employers shouldn't say, okay, great, I don't have to worry about discrimination based on sexual orientation or gender identity, because we believe that plaintiffs' attorneys are going to be filling in and filing suit on if the EEOC is backing off of that role. Misclassification is a big moneymaker, and it's something that the EEOC is not focusing on alone. They focus on it with the IRS, they focus on it with the state unemployment agencies, the state taxing agencies. So that's likely to stay. Under the Obama administration, the EEOC had really sort of pushed its power out to the regions, but we think that signals are showing that it looks like there's going to be a consolidation of power back to DC, and the regions will have less ability and less authority to kind of pursue things on their own. One positive for employers is that the new EEO1 report, which requires that employers give pay data by band within EEO codes, is potentially vulnerable to being pulled back, which is nice, because it's that's going to be a huge effort for employers to comply with. That will be due in 2018. But the good news is that the current acting chair, Victoria Lipnic, has been critical of that requirement on employers. She thinks it's too onerous, and so that's one area to pay attention to. It could be pulled back. Also, just so you know, this year, 2017, is the 50th anniversary of the Age Discrimination in Employment Act. And so whenever you have an anniversary like that, the EEOC likes to, do something special. They may pay special attention to age charges. So, this may be sort of the year that they really focus on if they get an age charge, or if they, get a call to look at a systemic issue in the workplace on age discrimination. Now, don't be thinking you can fall asleep if you don't have unions, right, when I talk about the National Labor Relations Board. As you guys all know, within the last several years, the NLRB has really tried to insert itself into every workplace, not just unionized workplaces. And employers have been really sad about this, because they've been getting charges, unfair labor practice charges from the NLRB, when they're thinking, this is the one agency I don't have to worry about. I don't have any unions. But basically, this the situation here is, right now they have 2 vacancies, and so President Trump will be able to appoint 2 Republicans to the board. And so there's some opportunity to change the direction of how that's been going, and pull back on, all of the action in, trying to affect non-union workplaces with workplace rules, with your handbooks and things like that. So it's not gonna happen overnight, but this is something to pay attention to. So first, the vacancies have to be filled, and so as you know, there are a lot of vacancies at the top, and so it'll probably be a while before those vacancies get filled, and then they have to get the right cases, and then they have to hear the cases and rule on them, and so it's just going to take a little time before the agency can kind of veer to a more pro-business course. Also, their general counsel cannot be replaced until the end of 2017. So, they're going to have the same person arguing on behalf of the NLRB until then. But there's three issues that I think employers are particularly interested in. One is seeing if they can sort of alter course on the Browning-Ferris case, which is dealing with the joint employer doctrine. And if you recall, that case basically said that if you as an entity have made a contract to get workers to help you out, and you have even an indirect right to control what those workers are doing, then you are a joint employer with the employer that actually hired those workers. And so that expands your potential liability beyond what you would like to have. And so that has been a really awful thing for employers. That's been a big concern, and a real big concern in terms of potential for union organization. And so hopefully, that's going to be one of those things that they veer more pro-business on. The other is employee handbooks. It's been extremely difficult for employers to try to figure out what's going on with Section 7 rights. How is it that confidentiality rules, that employee investigations, that, just regular basic workplace rules that have been in place for decades now seem to violate employees' Section 7 rights to protected concerted activity. And so there is the hope that they will kind of get more in line with going back to being able to have the same rules that employers have had for a long time. And then finally, I wanted to alert you to a fun case on secret recordings. There's a case called it's In Re Whole Foods, and the NLRB said that Whole Foods can't have a policy that just says no secret recordings in the workplace. And Whole Foods wasn't under any union organizing activity. Nobody could show that the policy was preventing any union organizing activity. And Whole Foods, in fact, showed they had lots of secret things in the workplace, like confidential information. They had employee discipline meetings. They had an employee emergency fund that employees could ask for funds for, if they had an illness or an emergency in their family. Lots of things they would want to keep confidential and not have recorded. But the NLRB said, nope, there's the possibility that, this rule may chill an employee's Section 7 rights. And so the Whole Foods has appealed the NLRB's decision that their policy is unlawful to the Second Circuit, and that was argued last Friday. So we're waiting to hear from the Second Circuit, how they come out on that decision. So that's a good example of a handbook policy that, normally you would think would be all right, but the NLRB has come down and said, no, can't have it. And then we have conflict, not like war or anything, but conflict between the EEOC and the NLRB. This past summer, the EEOC put out a big report on their task force on the study of harassment in the workplace. And basically what they found, if you want the one-line summary, it's about a 100-page report that they did. But they said that training in the workplace on sexual harassment actually isn't all that effective. We have just as much sexual harassment going on as ever. And so what it's doing is just telling people what the law is. It's not helping us to have a better workplace. And so we think it would be very helpful if employers did things like civility training and professionalism training, and you're going to get much further in avoiding sexual harassment with those kinds of things. And then they acknowledge, though, that the NLRB takes issues with having civility codes in the workplace, right? Because that might chill employees' ability to engage in protected concerted activity. And so their response was, well, the EEOC and the NLRB should work together to figure out a way that we can do this. So, Paul, you had a question?
Are there any vacancies on the EEOC?
There are not any vacancies right now. Jenny Yang's term who was was the chair until Victoria Lipnic was appointed acting chair because we flipped from Democratic to Republican. Her term ends this summer. And then I think a lot of the other commissioners have pretty deep terms going through the, through the administration. So thanks for your question. So let's talk about OSHA for just a second. With whistleblower investigations, these are all investigated through OSHA. And so if you have listened to anything under, that President Trump has been talking about, you hear about Dodd-Frank a lot. He really wants to get rid of Dodd-Frank. Well, what makes it partially relevant to employers is that there are whistleblower provisions in Dodd-Frank. And he has not said anything, nor have the people that work for him said anything about the whistleblower provisions. And so, it's possible that those may stay if any part of the act stays. But if they get rid of it altogether, that would be something that would be gone. Sarbanes-Oxley, has a pretty strong whistleblower provision, and the issue there is we think that it could be affected by judicial appointments. There are a lot of open seats in the judiciary, and I'll show you just how many a little bit later. But what has happened is in interpreting Sarbanes-Oxley and what it is that is protected activity under the Act, a lot of courts have been very broad in what employees have done that is considered protected activity, what is a proper complaint or what is not. And so that may be affected, but those still stay in place. So you still will have plenty of whistleblower protection. It just may be more difficult to fit whatever an employee thinks is protected activity under the definitions. The big thing that happened with OSHA last year is that they put in place some new reporting rules that was effective, I think, November 1st. And a big thing about their rules is they said that you have to be thinking about your post-accident and post-injury drug testing because you really, we require that employers avoid deterring or discouraging employees from reporting accidents. So, obviously that is very difficult for employers to do. They want to do the post-injury, post-accident drug testing to know if there was a problem. And so this is certainly mixed messaging from OSHA. But yesterday, the House voted to disallow this rule. And so we'll see if the Senate does the same thing. So this one very well may be pulled back, which is nice for employers because this was additional reporting, online reporting of accidents and injuries that occurred. So with respect to the personnel change, I thought this was an interesting quote by E.J. Dionne. This could be the most anti-worker, anti-union crowd to run our government since the Gilded Age. So we'll see if this happens to be true. Neil Gorse, the Supreme Court nominee, we don't know just a ton about his feelings on employees, but he's generally expected to be pro-employer. He appears to be anti-government agencies and anti-labor. And from what we can tell, his past decisions and opinions that he's written, they definitely question strong deference to agencies like the Department of Labor or the EEOC. So that is certainly a positive for employers. Here's our new nominee for Department of Labor. It's funny, when we scheduled this seminar, we thought for sure we would have a head of the Department of Labor, but then, no one expected that there would be, that the current nominee, his ex-wife would have gone on Oprah allegedly to disclose domestic abuse, and apparently the vetting process did not work just really well in that case. And so it was funny. I was talking this over with a friend of mine, but it's a low bar now. You just have to be basically qualified to run right, the Department of Labor, and you have not gone on Oprah, your wife has not gone on Oprah to complain that you have potentially, been violent toward her. So, this Alexander Acosta, he seems to be minimally qualified. He has a background of government service, which is good. He's been an NLRB member in the past. He worked as an assistant attorney general for the Civil Rights Division of the Department of Justice and prosecuted some high-profile people. And initially, his nomination received quite a bit of praise. Everything has been pretty much silent since then. And his hearing hasn't even been scheduled yet, unless that happened yesterday. There have been, the only negative on him is that there have been some concerns that he didn't supervise an employee who did some improper hiring and personnel decisions. This underling, that he supervised, was using poor judgment and not properly considering people. But for the most part, he seems fine. Here is our acting chair of the EEOC, and she was originally speculated as the potential chair of the entire Department of Labor. But she's been a commissioner since 2010. She was nominated by Obama as one of the Republican commissioners. And just so you know, one of her notable votes is that she was against the decision that sexual orientation discrimination is gender discrimination. And when the EEOC issued the guidance on pregnancy discrimination, she also voted against that guidance, which I thought was interesting. She was critical of the EEO1 report changes that are set to take place in 2018, and she was one of the co-authors of that sexual harassment task force report that I talked about that came out last summer. She and Chai Feldblum were the authors. So that is definitely, something that she's interested in. She participated recently in a speech that she had committed to before she became the acting chair, and she mentioned that some of her priorities. She said basically, I don't think the EEOC priorities are going to change, but she did mention age discrimination as a potential priority for this year, given the anniversary. And then here is your acting chair of the NLRB, and I feel very sorry for this man. He has been the lone voice in favor of employers for since 2013. You'll see him, he's the lone dissent. He always seems like the voice of reason to me if you read an NLRB decision. He's always like, what are you doing? This is crazy, and so I bet he's actually really excited. He may get some friends on the board, if they can ever get around to appointing some people. But so he was nominated in 2013, and his term ends at the end of this year. He was a former labor and employment partner at Morgan Lewis, and he has been very critical of NLRB opinions. And so right now there are 2 vacancies on the board, and so we'll see if those get filled. But I'm sure that he is keeping his fingers crossed that he gets some friends and he'll finally land in the majority on a decision, because he's been the dissenter in almost every opinion. Poor guy. But I thought you might like to see this slide about what kind of openings there are, and what if this if they can get it together. There's so many openings throughout the government, but you can see the federal judiciary is hurting right now. The Supreme Court will get filled, but right now 10% of the Court of Appeals are empty. And then I think this is huge, and we are feeling it big time in the Northern District. 93 of 677 spots in the trial courts, in the federal trial courts, do not have someone filling that spot. So that's a 13.7% vacancy rate, and that is a lot. And then I don't know if you care about the international trade or federal claims courts, but they've got openings as well, and they're smaller courts, so the percentages look really big. But the total vacancies out of all the federal judiciary, and this is as of yesterday, 121 of 890 spots are open, which just seems huge. And so, if you're feeling a slowdown, if you've got cases that aren't moving quickly, if you've got, issues like that, that is partially why. There just aren't enough judges doing the work, and so it's very difficult. And I will mention, just anecdotally, if you've got EEOC charges that are pending, or if you've heard that an employee has filed a charge against your company here in the Dallas area or in Houston, I can tell you that the investigators are completely overwhelmed. I mean, they are not progressing on those charges quickly at all. I've seen them lingering for 9 months, a year, 18 months. It is insane because they don't have the personnel. And so, they can't just keep assigning charges to the investigators because the investigators don't have time to get to them. And so they'll just leave them in the queue as unassigned for a long time. And it's killing the plaintiff's lawyers, it's killing the investigators. They just don't have enough people. So that seems to be a common thing right now. And I frankly don't think that the EEOC is going to get much attention from this administration either. So we will see what happens. So very briefly, let's talk a little bit about transgender or gender nonconforming employees and what's currently going on. So this is the EEOC's position, which frankly is the most important for employers. And the EEOC takes the position that Title VII prohibits employment discrimination based on gender identity or sexual orientation because it prohibits sex discrimination. So according to the EEOC, that means you can't fail to hire an employee because they're transgender. You can't fire someone because they go through a transition to a different gender, or harass an employee for those reasons. And so when it comes to using the restroom, if you deny equal access to a restroom that corresponds to what the gender the employee identifies with, that would be sex discrimination. And so you can't condition their right to use that restroom on proof that they've had a surgery or that they're going through a transition or anything like that. You also can't restrict a transgender employee to a single-user restroom. That would also be discrimination. So, just so you know, that's the position that the EEOC is taking. OSHA similarly has said that restroom access is a health and safety matter, and everyone should have prompt access to restrooms. They suggest that you have either single occupancy unisex restrooms or, maybe, is everyone here familiar with Ally McBeal? Do you guys remember that show? Remember how multiple occupant, gender neutral restrooms, right? That's kind of what they're envisioning. But, barring completely remodeling your facilities to meet the Ally McBeal standard, employees should access the restroom of the gender that they identify with. So that's the current OSHA position. So where we're seeing all of the hoopla really is with interpretation of Title IX. And back in May of 2016, Department of Justice and Department of Education issued a Dear Colleague letter. And what they said is that, the Title IX prohibition of sex discrimination extends to discrimination based on gender identity. And they said that transgender students must be allowed to access facilities consistent with their gender identity. That includes restrooms, that includes athletics, it includes same-sex classrooms and housing. But they did say it doesn't include single-sex schools and sororities or fraternities. But February 22nd, these departments rescinded that previous guidance. And so now people are just unclear on what remains. Because the end of the letter that rescinded the guidance said, please note that this withdrawal of the guidance documents does not leave students without protections from discrimination, bullying, or harassment. So what does that mean? All schools must ensure that all students, including LGBT students, are able to learn and thrive in a safe environment. So we've just withdrawn our guidance that was very specific about what you have to do, And now we've just said you have to keep people safe, and they can't be harassed or bullied or discriminated against. So hey, schools, you guys decide what you need to do. So that's not very satisfying. And it's interesting, this issue is actually set to be argued in the Supreme Court this month. There's a teen named Gavin Grimm who was born female but transitioned to male, and he sued his local school board for violating his rights by not permitting him to use the boys' restroom, required that he use the girls'. And so the trial court dismissed his claim, but the Fourth Circuit reversed and said, no, he should be able to use the boys' restroom. And U.S. Supreme Court set the case for oral argument this month. And it's interesting, just sort of who knows what will happen, but one of the amicus briefs was filed by a real conservative, a religious sort of nonprofit law firm called Liberty Counsel, and the Supreme Court returned Liberty Counsel's brief to them and said, hey, it was filed as, Gavin Grimm, or because it wasn't filed under Gavin Grimm's name, because at the time the case was filed, he was under the age of 18. So it was, GG, and it used a male pronoun, but Liberty Counsel's brief used female pronouns on the heading, and then all through the brief used female pronouns because Gavin Grimm was born a female. And so the Supreme Court actually returned the brief to Liberty Counsel and said, no, we're not having this. You have to refer to Gavin Grimm using male pronouns. Like, don't get cute with us. So that was kind of an interesting thing that happened right at the end, I think the end of January. But I will tell you that since the agencies, since the DOJ and the Department of Education pulled back their guidance, this past week, the Supreme Court has sent a letter to the parties in this case asking them to recommend a course of action, because a lot of what the Fourth Circuit had based its opinion on were those guidances. And the school board has said, well, we don't even have a U.S. Solicitor General to brief this issue. We think that you should delay oral argument to allow a Solicitor General to be named and then let them submit briefing, and so let's just push it off. But Gavin Grimm and the ACLU, as representing him, have said, we think we can go forward with the original date, this March. So we'll see. This one is in flux as well. This is one to pay attention to. So what do you take away from this? Right now, I don't think you can, as an employer, there's not a good reason not to protect employees from discrimination on the basis of gender identity. It seems like there's not going to be anything more specific about, how to handle it. And so, you're going to have discretion, I think, on how to address bathrooms in your workplaces. We will probably have more litigation, not less, because when your standards are more vague, there's more likely to be more litigation. So we'll see what happens with the Grimm case. It may be delayed. I would guess that it will be. And it may not be decided on the merits due to the pullback of the guidance. So we'll just have to see. There are a lot of employees who are experiencing, discrimination based on gender identity, but when they're filing charges, in almost every case, they're filing charges based on gender identity, and they're also filing charges that include other types of discrimination as well. So it's, they're not just saying I'm only being discriminated against because of my decision to transition to a different gender. And so this is an area where, you want to be careful about how things are pushed out to employees. So, future of paid leave. Just a little level setting. The U.S. is the only high-income country and only one of 8 countries worldwide that does not offer paid leave. We have the FMLA. If you meet a certain size and if an employee's worked for you long enough, you get 12 weeks of unpaid leave. We're seeing across the country some states that are requiring paid leave. We see some states that treat childbirth as a temporary disability, so you get disability benefits. You see some states that lower the number of employees that are required, that lower the number of months that you have to work for the firm. So now it's starting to get more difficult for employers, because you've got to take into account what's going on at the different states. You don't just have the federal FMLA standard. And so what we see a lot are that employers take up the slack and provide as an employee benefit paid leave to mothers who have a child. So what's the future? This is like the one thing that Clinton and Trump agreed on, is that there should be some sort of paid parental leave. And during the campaign season, President Trump and Ivanka Trump both specifically talked about having 6 weeks of paid leave for new mothers. And so that'll be interesting to see if there's something that comes about with that. That's something to watch out for. It's unclear whether that would be enacted through changes to the FMLA, if it would be something that occurs with temporary disability benefits, which is how states like California have handled paid leave, or if there are other solutions that may come about. But if you listen to President Trump's speech on Tuesday night, he was even more vague about this. He just said, and I kind of wrote down his quote, "My administration wants to work with members in both parties to make childcare accessible and affordable, to help ensure new parents have paid family leave, to invest in women's health, and to promote clean air and clean water, and to rebuild our military and our infrastructure." So that's all the specificity that we have right now. But this may go the way of paid sick leave, and you may see states, you may see localities that require employers of a certain size to do this kind of thing. It may be unsupportable, or we may see something adopted, in the years to come. But we'll just have to wait and see. So, Mark?
My turn. All right.
Finally. They're tired of listening to me.
No. So you've hit the tax section, because nothing's as pretty and as cool as what Jennifer does. It's very, it's tax-ish. And Jennifer tells me, add pictures, quotes, things like that. I'm like, well, my teenage daughter's gone to college, so I don't have lost my IT expert. So you're lucky I got this much. But I thought what we do is two things here. One, kind of talk about what we don't know or do know, or what we'll see on employee benefits with the new administration. And we don't know a lot, but we know some things. And then I thought we'd talk about some things I do know about, which is guidance that the IRS has put out for 401k plans, since most people have 401k plans. That actually is, for the most part, pretty good. Kind of under the radar with everything going on with the administration, but the commissioner's office is still putting things out. I don't know if they're subject to the 2-for-1 rule, but where you're supposed to get rid of 2 regulations for every one. But they are doing things. So let's start with kind of what was promised during the campaign. And I put some of the big items there. It was at first repeal, and now it's repeal and replace Obamacare, tax reform, immigration reform, infrastructure investment, filling the vacancy on the Supreme Court, and eliminating many of the Obama-era regulations and executive orders. And during the first 6 weeks of the presidency, Mr. Trump did sign a number of executive orders consistent with those priorities, and then nominated someone to replace Justice Scalia. I will say, if you're looking for any insight into Judge Gorsuch's thought process on employee benefits, he was one of the judges on the Hobby Lobby case out of the 10th Circuit. But other than that, one of the concurring that let that go forward. But other than that, he's really not had any cases that are on a lot of the hot button items that we care about in my area, stock drops, the fee cases that are going on, the church case, the church plan litigation. None of that is really retiring medical. None of that has he really touched upon. So I guess we don't really know what he's going to do when he gets up there on those types of cases. In addition to ACA, the Department of Labor's fiduciary reg or conflict of interest reg has certainly been in the crosshairs of the administration, as it has been with the Republicans before the new administration came in. And then I would say that when you talk about tax reform, you can't talk tax reform without thinking about the impact on retirement benefits and executive compensation. And we'll talk a little bit about that in just a second. Jennifer went through kind of the agencies and where they are. For what would be important in my area, of course, is HHS, DOL, and Treasury, because those are the three agencies that are responsible for Obamacare or ACA, and I assume they would be doing whatever you have to do. They would also, with the new law, that they will be involved in that. As Meatloaf says, 2 out of 3 ain't bad, but maybe it is bad here because we only have 2 of the 3 agencies with heads. We're still waiting for the Department of Labor, and even more importantly, we need the Assistant Secretary of EBSA, which is the operating group under the Department of Labor that's charged with ERISA plans. And so they're really the group that worked through the regulations, the reporting requirements, working with Treasury, working with IRS, working with HHS for all the Obamacare regulations. So until we get that, we'll see. Turning to the ACA, of course, this is something that President Trump said he would get rid of and now get rid of and replace. If you listen to the Republicans, in particular Chairman Speaker Ryan, he will say that they have to deal with ACA first before they can get to tax reform. They can't do tax reform until they deal with ACA because ACA has such an impact on taxation. I think that makes sense. They're taking the view of trying to address everything at once rather than a piecemeal approach where maybe using budget reconciliation to deal with the taxes, and then they can't use budget reconciliation for the insurance reform. So they really want to handle everything at one time. On the first day he was in office, President Trump put out an executive order basically saying they were going to appeal ACA. It was an interesting order. It said that the executive branch will ensure that the law is being efficiently implemented, take all actions consistent with law to minimize the unwarranted economic and regulatory burdens of ACA, to prepare to afford states more flexibility to control and create a more free and open healthcare market. And then there were some other kind of subparts of that, all of them couched into the maximum extent permitted by law, that these agencies would take basically steps. When you look through what I have here, they're basically things like waiving, deferring, granting exemptions, doing anything to not have different parts of the act apply. And the other side of it is to give more authority and control to the states and try to get rid of the barrier of insurance policies being able to cross state lines, which the Republicans think is a huge issue and why we have cost issues and why ACA doesn't work. And we can talk about why, I'm not going to get into ACA and issues with that. You guys deal with it. You have probably your own thoughts on that. That's a whole day's conversation. So I think it's important to note that the executive order focused really on individuals and states. It really didn't focus on employers. It didn't get into the employer mandate. It didn't get into the penalties. It didn't get into the reporting aspects of it. It's unclear how much agencies can do to stop and not implement a law. I mean, this isn't a regulation. This is an actual law. And again, 2 out of 3, until we get all 3 heads of the agencies there, how much can they really do? So I think as we sit here today, nothing's really changed. I will say that we're supposed to hear and see the new act that's being proposed in March, and it's March 2nd, so they're late. I understand that some version of it leaked out. I haven't spent any time looking at it because who knows what that is. But certainly something is expected to come out this month, and quite frankly, I think it has to if they really want to stay on the time schedule of getting to tax reform. So stay tuned. Speaking of tax reform, it's a major priority not only for the administration but for the Republicans, has been for a while. And again, they have to get the ACA done before they go to tax reform. Speaker Ryan, last time I heard him speak about this, he said probably the fall they were looking to do something with this. Kevin Brady is the Ways and Means chairman, who's also very involved. He's a Texan and wants to move this forward also. During the campaign, you heard we're going to reduce income taxes for both individuals and corporations. But to do that, they've got to find some money. And when you think about the tax benefits, the kind of negative tax aspects of the code, it focuses on employee benefits, right? 401k plans, pension plans, and also some deferred comp arrangements. From the campaign trail, both candidates carried interest and said they would do something with that, but that's not going to be enough. If we look at past tax reform acts that have been promoted, the CAMP Act is a good example a couple of years ago. There were things in those acts to address and cut back retirement and executive benefits, such as freezing the indexing for qualified plan limits. If you had a Roth accounts, not letting you do more than 50% of pre-tax, everything had to be in Roth. Getting rid of Section 162M. I don't know how many of you have to deal with that, but that's a deduction. If you got rid of it, then some of these high executive salaries would no longer be deductible. And then from a deferred comp standpoint, taxing everything whenever there's no longer a risk of forfeiture. So essentially, when you vest in it, you're taxed at that point in time rather than being able to push it off to some time in the future. It's really unclear what Congress will do with this. They're not really focusing on it yet. They may take one or two or none of these things I have up here and go a totally different direction. Wouldn't surprise me, but stay tuned on that one. Thank you. I do want to talk about the fiduciary rule next, because again, that was one of the, outside of ACA, that was the other benefits issue that the administration has really talked a lot about. All administrations, new administrations, when they come in, will do an executive order that basically stops any regulations that are in process. Unfortunately, the DOL Fiduciary Rule was effective in 2016, even though it's not applicable until April 10th of this year. And so the executive order had no bearing on that. That meant that the only way to stop the fiduciary rule from coming into play was either legislatively or from a regulatory standpoint. In Congress, the Republicans did do some legislative efforts that are out there to repeal it. The Democrats are not in favor of that, and so that's going to be a pretty long, drawn-out process. And when you look at from a regulatory standpoint, since it is a final effective regulation, you have to go through the proper administrative procedures to get rid of it or make changes or delay it, which means notice and consent. So something that is new, that's not in here because it just came out today, is the new fiduciary rule delay was published. We are in a notice and comment period, so you have 15 days to give them comments before they can act upon it. It would delay the fiduciary rules application date. Remember, it's already effective until June 9th, and so a 60-day delay. And if you look at the proposed rule, it's 31 pages long. It has a ton of questions that they want comments on. It basically directs the Department of Labor to go back, redo all your economic analysis and your legal analysis to figure out whether this thing really works or not. Yes, sir?
What exactly is the DOL Fiduciary Rule?
So the Department of Labor Fiduciary Rule, I apologize. Good question if you don't know what it is. So under ERISA, for years we've had a fiduciary rule regarding advice for investments. That rule came in at a time when we only had pensions. We didn't have 401k plans. You didn't have people investing their own money. With the rise of the 401k plan and also with the rise of IRAs, there's a real concern, and I think justified concern, that people don't understand the fees that are getting charged and that there's a lot of conflict of interest out there. Brokers will sell you something because they get a commission, but maybe it's not in the best interest of the individual. And I think it's a legitimate concern. Unfortunately, the rules that were in place from 1974, which was the original fiduciary rule, didn't pick up any of that. And so the new rule broadly expanded this fiduciary duty requirement for people who make investment advice or suggestions. And it also goes beyond 401k plans. It also goes into IRAs, which is where one of the big sticking points has been, because it's arguable whether the Department of Labor really has authority over IRAs. It's really the SEC, and there have been there are 5 cases that were filed, 5 actions that were filed. Some on that issue, they exceeded their authority, and some that they just didn't do the administrative part right. It also adds a private right of action, because they're really picking up for the plaintiff's attorneys to kind of carry a lot of the water on this. And that was another issue that was been brought up in a lot of the cases. Hey, can you really do that? Can you really create this private right of action? So it has substantially changed how you'll be doing business in the future, whether it's a 403B, whether it's a 401k, any participant-directed plan, because that's really what it's hitting. And it does make sense. I mean, pension plans, you have professional money managers doing the money and handling the assets, and they're always fiduciaries. And so it is kind of filling in a gap. The question is whether it's too broad. And the big push, of course, has been by the investment houses. They hate it, right? They hate this thing. As a plan sponsor, it has some implication to the plan sponsor, because plan sponsors are the committee, if you have a committee, or fiduciaries also. But it's really impacting the financial community more than anything else, because it's just changed all the rules. What I will say is, even if the rule goes away, a lot of these financial houses have already restructured themselves. They've spent millions of dollars. Fidelity is a good example. If you have Fidelity doing any of your 401k plan, you probably got a letter saying, hey, we're a fiduciary now. And they've restructured everything to comply with the rule. And so the question is, even if they get rid of this rule, does it matter? I mean, have we already moved so far down the road? Is Fidelity going to spend, and I'm not picking on Fidelity, but they're a good example of this, so are they going to spend millions of dollars and restructure their business again to go back to the way it was? And if they do that, and you're a plan sponsor, are you going to say, wait, you just told me you said you were a fiduciary, now you're not a fiduciary? And then it also kind of raises the issue, well, what will the plaintiff's attorneys do with that? Are they going to come in and say, wow, we have the roadmap here? And so it may be that the cat's out of the bag, as they say. Is that what they say? The cat's out of the bag. The cat's out of the bag, or the genie's out of the bottle, or the milk is spilled, whatever you want to say. But it may be that even if the regulation goes away, that from a practical standpoint, we're there, at least for 401k plans and 403B plans. The IRAs are a totally different issue we won't get into that. One thing that's interesting is I don't know how this impacts with the 2-for-1 rule, right? So we'll see if we have to take 2 rules away and get 1 back. And maybe you have your chips now, right? I only have so many regulations. So anyway, a lot of fun. But that's hot off the presses if you want to read that. Read it at night when you can't sleep. Pull that up. Let's talk about the IRS, because they have done some things that are new. And I don't know, do you guys have, anybody have individually designed plans, or do you use prototypes? Maybe not. So the IRS issues determination letters, used to issue determination letters that basically said your plan is meets the qualification requirements for individually designed plans. So those are non-prototype plans. They have stopped doing that. Been kind of big issue for people in my area, for companies that have individual design plans, because they can't get these determination letters anymore, except when basically if your plan's already in play, whenever you terminate your plan, or if IRS reopens the window because there's a law change. So what they have done, though, is they've started putting out these required amendment lists. The first one came out in December of last year that tells you when there's a law change that you need to update your plan for. It gives you 2 years from the date that it goes on that list to get it done. The other thing that they did, and this is hot off the presses, they now have a operational compliance list, and it's on their website. It's not a regulation. It's actually on their website. And this is designed to tell you, hey, you may have 2 years to adopt this amendment, but operationally, this is effective on a particular date, earlier date. And so it tells you what day certain changes are supposed to be, from an operational standpoint, complied with. And it's an interesting thing. It goes back, it just lists all the different things that have come out in the last 3 years and tells you when you should be complying with it. So that'll be something to watch also. Something else they did, which actually is very good, they changed the rules on QNEX and QMAX, which are if you do testing of your 401k plan and you fail, one way to fix it is to put some money in for the low paid. But you used to couldn't do it with forfeitures. If you had a match with a vesting schedule and somebody left and you forfeited that money, you used to couldn't use that money. They've changed the rule to now that you can use that money. So that's actually a good thing. And you can rely on that now. And they snuck that one in. That sounds so bad. They got that out on February 17th. And the final thing that I want to mention, and this is actually hot off the presses too, just the other day, hardship distributions and substantiation of hardship distributions under a 401k plan. If somebody has medical issues or burial expenses or is buying a new house or is about to get foreclosed on or has education expenses, you can access money in your 401k plan as a hardship, and you can go up to the amount that you need. Unfortunately, a lot of the record keepers now, they want everything electronic, right? And so they don't want paper. And so they would say, oh, we'll just have the participants self-certify that they've got this issue, and we'll cut them a check. The IRS took issue with this a couple of years ago and said that's not good enough. And if we find that on exam, we don't think you've substantiated the hardship distribution, and they can send you to audit cap, which basically means you could be paying a sanction, which the sanction would be paid by the plan sponsor, not by the participant. So they've got a program called the Industry Issue Resolution Program, and this is the first employee benefit type issue that's been heard under this program. It just got opened up for our area last year. And so now what they came out with from these meetings with the record keepers is that if you have a summary of the documentation, the source documents, if you don't want to keep the source document, if you have a summary of it, and basically it's a questionnaire almost, and if you check off the boxes, you've got this, and you kind of fill in what you have, the record keepers can now issue the hardship distribution. If the IRS comes in on audit and looks at the summary, if the summary answers look right, then they'll leave you alone. They'll say you're fine. But if there's an issue, they're going to ask for the source documentation. Or if you take 2 hardship distributions in 1 year for an individual, they're probably going to want to see the materials also, because that doesn't look right. As a plan, it's great for the record keepers, right, because they can continue to use this kind of not paperless way to go. But if you're a plan sponsor, you probably are going to want to look at those questionnaires. The TPAs are supposed to give them to you annually. You're also supposed to give a notice out, and so you'd have to prove that the notice was given to the individuals to explain kind of the tax issues for the hardship withdrawals. But you might want to be looking at those summaries, and if something looks kind of squirrely, going to the participant and saying, let's see your source documentation. And if they don't have it, then fixing it before the IRS comes in. So, but that's new too. I don't know if you guys care about this, but the IRS does have like a newsletter it puts out every so often. And all these things just hit the brand new newsletter that came out while Jennifer was talking. So see